All right, mommies, listen up because Texas just raised the stakes on custody interference. So they now have a three-strike rule, meaning 3 strikes of custody interference and you're out. Or I guess in this case, actually in state jail for a felony. So the first offense, misdemeanor, $500 fine. Second offense, you are on very thin ice. The third offense, it is now punishable for up to 2 years behind bars.
Texas just said we're done playing games. 3 strikes and you're catching a felony. Not a slap on the wrist, not a strongly worded letter. Actual prison time. And the family court angle is what makes this lethal. Criminal charges and losing custody, that's a two-front war most people can't survive. Dads have been getting legally kidnapped from their kids' lives for years while courts shrugged. Now there's actual teeth in the law. About time.
Okay, the twist is that this isn't just about criminal court. This is not just about charges in a criminal proceeding. Family courts can also use these violations, okay, to flip custody to the other parent or award the cutoff parent double makeup time, attorney's fees, all the things that you would typically see in an enforcement of possession and access. But they are cracking down, okay? Some say this finally gives dads real protection when they've been shut out of the kids' lives, okay? And others say it punishes moms who are just trying to keep their kids safe. But if you ask me, I think that most moms who are withholding for safety reasons are not the first ones to have the money to hire an attorney and file a modification and let the judge know what's going on if CPS has already ruled out the allegations, okay?
She actually made a fair point here. Broke women without lawyers are more vulnerable to this law hitting hard. But let's be honest about why they're broke. Years of using court as a battlefield drains everyone. You weaponize the system, now the system's pointing back. CPS cleared him. That's the whole story.
So this is a very real scenario. I'm not saying it's every scenario where a mom or a parent is withholding the child from the other parent, but I think that this law could definitely hit the most vulnerable the hardest if they find themselves in those cases, right? Also important, only custody interference charges that happened after September 1st, 2025 will count towards the 3 strikes. So they're basically giving people a clean slate, okay? So what do you think about this? Do you think that it's definitely going to hold parents accountable, or do you think it's another law that's just going to drag more families into court? Let me know your thoughts.
Have you guys heard about the new, what's it called, 3-strike custody law in Texas? So apparently if you withhold a child or something like that, I can't remember how it goes, but I believe the first time that it happens, they give you like a warning. The second time it's a $500 fine, and I believe the third time is you go to jail. They're going to go to jail for it. Now, sounds great, right? I think this is exactly what we need. But now what I'm promoting is this is going to be used towards moms. Moms who are trying to keep their children safe against a dad who's abusing them. Now, before you go jumping down my throat, oh, you're not, your mother's rights. Well, I am for mothers. I am a mother. And my business, I do peer support. So I can only do peer support with mothers because I'm mother, they're mother, and yeah. So anyways, got off track there for a hot minute. So, I remember where I was going with this. I just completely drew a blank. Oh, so there are actually studies that have been done where when fathers, go to jail, they commit crimes, they do whatever, have misdemeanors, it's never held against them.
Okay, so her argument is basically, men get away with crimes, but women don't. Even if that's true in some cases, how does that justify keeping a child from a parent who hasn't been convicted of anything? You don't protect kids by punishing innocent parents. You're not a shield. You're a roadblock. And now Texas is treating you like one legally.
But with mothers, it's held against them. And I believe I have it on my Rumble. So I'm going to try and go back to my Rumble, and I'm going to try and get that information. I'll take like a screenshot, and I'll try and add it below so you guys can go check out the study or the information as well.
I don't know if y'all saw this, but Texas added a couple rules September 1st in the law, so this is what you should know. One of the biggest changes that involves child support is that parents with a net income of over $140K will see an increase of about $500 a month. I don't know, child. I ain't gonna help my baby daddy not once, but for one child, 20% of support is calculated at about $23.40 per month, effective September 1st. I wish. Also, another one, the judge can grant one parent to have a choice over which school the child attends. Now, I've never heard about this one before, but there's a new law that prohibits a controversial form of therapy used in parental alienation cases. I have never heard of that before. There's a lot of fucking words. Now, this next one right here is the most groundbreaking of them all. The visitation enforcement. It says to protect parental rights, Texas created a 3-strike rule. If a parent is found in contempt 3 times for blocking visitation, the court can use that record to potentially remove them as the custodial parent. Y'all. Y'all, these new laws are already in effect. 3-strike rule to baby is crazy.
This is the part nobody's talking about loud enough. Jail is temporary. Losing your kids to the other parent, that's a whole different dimension of consequence. You don't just do 2 years and come home to your family. You come home to supervised visitation and a judge who already made up their mind about you. 3 contempt strikes and your entire custody position collapses. That's not a punishment, that's a demolition. Build the right record or lose everything. Simple math.
Guys, another incredible win. This one is from our portfolio of evidence service that we put together for you guys. And she was getting 1,000 Rand a month. That's it. Her first court appearance, portfolio of evidence with everything in it. She walked away with 5,000 Rand plus clothing for Christmas. You know what? I salute you. When it works, it works. Prep is everything. And that got her 5,000 Rand a month. So, well done, Mama Bear. You know who you are. So proud of you.
We have breaking news out of the White House. So Donald Trump, in fact, never addressed child support. So everyone was expecting him to say, okay, only paying parents can claim the child. There's a brand new tax credit for those of you who do pay child support. None of which happened. So Donald Trump did address a couple things, like the government will now only recognize men and women, or female and male, for genders. He did address that he's going to pardon himself and his entire family. 17 convictions, never been to prison. Sound familiar, huh? Other than that, I know everyone was really expecting him to say, oh my gosh, I'm here for the men, I'm gonna change child support for you. Unfortunately, that did not happen. So there's no changes expecting to happen anytime soon. There is nothing in the works. Google is free. That is where you're going to find any information that might be missing from some other videos, from my videos. Just go ahead and search new laws for child support. You're not going to find anything. So if you have any questions, please let me know.
Respect to her for being straight up. No new federal child support law. No tax credit switch. Nothing. But watch how many people already made decisions, stopped filing, started hiding income, told their baby daddy something crazy, based on a viral TikTok with 0 sources. The damage is already done before the correction even gets half the views. That's the real problem with legal misinformation. The lie travels at light speed. The truth walks.
Hey y'all, just was wondering if anybody heard about the child support law that's supposed to be taking effect. I'm not for sure if it's going to be this year or next year, but it's the Trump administration was allegedly putting out that normally not the custodial parent that receives the child support was then turn around and claiming the kids at the end of the year for child support. Now that's about to change. The non-custodial parent that is paying child support will be the one that will be authorized to claim said children at the end of the year for taxes, not the custodial parent. Meaning, if you put a guy or female on child support, what you're doing is you're saying you're going to give up your rights to that end of year tax credit, okay? So I'm not sure how that's going to be written in a tax law, but a friend of mine that works at the Attorney General's office, I called her and asked her about it. She said, yeah, that's what they're hearing. And Department of Health and Human Service, I have a good Judy that works over there, and she was telling me the same thing. So you better look it up because every state is different, okay? All right, y'all have a great day.
A friend at the AG's office told me, followed immediately by a good Judy at Health and Human Services confirmed it. Bro, that's not research. That's gossip with a government uniform on it. You're out here potentially changing how people handle custody and child support based on hallway conversations. If it's real, there's a bill number. There's a signing date. There's a press release. Find it or stop spreading it.
Hey everybody, welcome back to Weird Law Wednesday. My name is Danielle Bakes and I'm a licensed attorney in the state of Mississippi practicing out of Mathiston. I want to talk to you a little bit today about a issue that isn't weird per se, but a lot of people deal with it on a day-to-day basis. So as most of you know, I am a private attorney. I'm also the Webster County prosecutor, but a huge part of my practice is divorce and child custody. So I want to explain to you how a chancellor determines where a child is going to live for the majority of the time. The paramount consideration that a judge is going to think about is what is in that child's best interest. And that doesn't mean, oh, mama is a really, really, really good mama, and so she's the one that's going to get custody. That's not how it works. Instead, the judge is going to analyze your case using the Albright factors. And any attorney that you sit down and have a consultation with, if they're worth the Esquire behind their name, is going to use the same type of analysis to determine whether or not to take your case and be able to give you good legal advice. So Albright is based on a case called Albright versus Albright, and it's a laundry list of factors. Some of the big ones are going to be continuity of care. So that asks the question, who makes breakfast? Who gives the baby a bath? Who takes them to school? Who takes them to the doctor's appointments? If that's you, then most likely you won that factor. Some other considerations to take into account are age and sex of a child. Interestingly, that Albright factor, for the most part, no longer matters. We don't care if it's an infant. We don't care if it's being breastfed. That is no longer a reason for the child to go with either the mother or the father. Some other things to consider are employment of both parents, not only their ability to provide financially, but who has the freedom through their employment to be able to do all of the things that a parent has to do. Who can take off work the most to take them to the doctor? Who can go to the baseball games? Who can coach Little League soccer? All of those things the judge is going to think about. They're also going to think about the morality of the parent. Is one parent more moral than the other, or has one parent made a horrible mistake that the other hasn't, like some sort of a felony arrest or an affair? That's a big one, whether adultery has occurred. They're also going to look at the community involvement around each parent. Do you have a support system there that's able and willing to help you whenever you need help? If the child is over the age of 12, the judge is going to consider their preference. Now, that does not mean that a 12-year-old gets to decide where they're going to live just because they're 12. No, a 12-year-old's preference matters much less than a 17-year-old's preference. And in either case, it's just another factor that the judge uses to determine what's going to be in their best interest. It's a laundry list of factors. I think there are 12 in total, but at the end of the day, the thing you have to keep in the back of your head is best interest of the child. That is what the judge is always going after. That's what any good attorney is going to tell you. I'll see you next time. Keep it weird, keep it lawful, and always read the fine print.
This attorney just gave you a masterclass, and most people will scroll past it looking for drama. Best interest of the child isn't just a phrase. It's a checklist. Who feeds them, bathes them, takes off work for the sick days, shows up for the games. That's what wins custody. Not who cried harder in court. Not who told a better story. The parent who can prove consistent, daily, boring, beautiful involvement. That parent wins. Document everything, starting today.
2017.
Okay, tell me about what's happened since 2017.
They felt that gave them an opening to that they had power with the judge, and they have continued to, push that. They have continued taking the children to that woman. That's, like I said, that was the majority of the bills they're trying to recoup. That was like $8,000 to this therapist that they used as a witness. She works with their attorney with all of his clients. They have taken my children, they have taken my company, and they have taken my income because they can, because they are friends with the judge. And that's why, if you can see, I don't know if you can see the previous hearing when we had the mediation, and Mr. Price said, we'll take it to Vanderpool because he knows that he can take it to Vanderpool. And he was excited to take this to Vanderpool, unaware that we would come to you.
Ms. Patterson, I'm concerned only with what's happened since the last order.
Okay. All of that has happened since the last order. I'm not sure. I apologize. I'm not sure I understand what you're asking. What would you like from me?
Okay. All right.
My income has decreased substantially due to Mr. Price's intentional attack on my income. And for some reason, he knows he took on my income, but is still not willing to admit that in court, that the income is not there anymore because of that.
All right. Based on the testimony and evidence before me, then, I am ordering Ms. Patterson to pay Mr. Price child support of $468 per month, dropping then down to $374 once the oldest child emancipates. That's based on your salary at the chamber office. I'm ordering Ms. Patterson to pay Mr. Price $280 per month for health insurance, as well as half of any medical bills not covered by the insurance. I'm not going to address the medical bills. Those haven't been paid for. Mr. Price, if you want reimbursement for medicals, you have to look at your last order and request the AG's office to do a special pleading for the medical reimbursement. We'll clear it up from now on out. Everything is half and half.
Yes, ma'am.
You need to send from now on out, you'll send Ms. Patterson the bills or copies of the bills on a regular basis, and she'll have 30 days then to reimburse her half. I'm going to waive court costs.
Thank you.
Is there any other relief I have not addressed, Ms. Neal?
No, Your Honor, I believe that's it. Thank you.
All right. And I don't have a drop down on the health insurance since it's actually costing $280 per child.
Yes, Your Honor.
Either of you gets access to some other kind of health insurance, it would be beneficial to everybody, I'm sure, to get a lower costing policy in effect. So if you do find one that you want to enroll the children on, what you'll need to do that costs less is let the AG's office know, and they'll file to modify the health insurance and order somebody to pay it, as well as correct the amounts for the cost.
Yes, ma'am.
All right. Ms. Neal is going to prepare that order for my signature. I'll sign off on it. There is a period of 3 business days during which anybody can request a new hearing. If you request a new hearing, you get a hearing in front of Judge Vanderpool, and he would start over and make his own decision. But if nobody does that, this order starts to become final, and you should get a copy by email or by regular mail within at least 2 weeks. And Mr. Price, you need to give Ms. Patterson a copy of the card, so if she's got the children, she can use it. If there were to be an emergency, they could not get even admitted to a hospital. So give her a copy of the card, and also a copy of the policy or an idea of the policy if there are doctors that are like it's a preferred medical or something like that, so she will know who accepts this insurance. It's available through your HR. Okay.
Yes, ma'am. Thank you.
All right. Good luck to you all. Thank you both.
Thank you.
Thank you.